Hi friends from around the world. We are here today with regards to copyright and trademark. At the end between one and the other, but the focus of this session is in copyright. And it is an interesting case here. It is, how to say, instructive. So I chose that one for educational purposes because we have here in reality a kind of masterclass in the form of a decision from the Boards of Appeal of 2018, I think. So what is it more or less about? It is about Article 60, paragraph 2 of the European Trademark Regulation. It exists the possibility, according to that provision here on the screen, that a copyright is a ground of invalidity for filing a ground of invalidity against a trademark registration. So far, so clear. Now, you have to know, and you know probably already, if you have listened into the level 2 videos, that the copyright is a national right within the European Union, meaning that all the member states, they have their own title, their own copyright. It is not that we have one copyright for the whole European Union. What we have is a harmonized right, so it is more or less the same in each country of the European Union, but still it is a national right. And generally, the copyright is not registered, so it is acquired in a different way. We will come to it. So this is the background, Article 62. And the case is about precisely this. We have a trademark application, which is Manufacture PRIM 1994 here on the screen. This was registered in 2005 already at the EUIPO as a trademark, normal trademark. It was for different classes, but you don't care about the classes here. So it was registered at the EUIPO as a trademark. And in 2014, there was an invalidation request from two individuals, let's them call A and B, from the Czech Republic. Also, the owner of the trademark is from the Czech Republic, so it's a kind of Czech internals, and there's a kind of history between those two, and there's a triangle even with another company for previous, litigation, but we do not care about this at this moment. It will be too complicated to get into this. So they filed an invalidity request on the basis of the Czech copyright, which is PRIM here on the screen, just like that, PRIM. Okay, so the invalidity request has been rejected by the Cancellation Division of EUIPO and came to the Boards of Appeal, A and B. They appealed to the Boards of Appeal, and the Boards of Appeal decided in 2018 on this with a proper decision, which I will discuss a bit more in detail because it is easier to read. It is a kind of masterclass, I would say, on copyright. Well, we will come to it, and then it went to the General Court, which confirmed in January 2021 the decision of the Boards of Appeal, but it is not as instructive as the board's decision. So that's how it is. Let me go a bit into the board's decision now. The applicant, so the applicant of the invalidation request, A and B, they claim to be the heir of the deceased R, which is a famous typographer and designer in the Czech Republic. and they presented a kind of certificate that they are the heirs half and half of that person. And that person are, in the Czech Republic in 1968 or so, he coined what is PRIM as a copyright, which after that in 2014 was registered as a copyright. PRIM, just like that. So, and they presented a kind of, what was it, a kind of meeting agenda, or not agenda, protocol, meeting protocol of 1968 of the Ministry of Commerce and Trade, etc. And they found this in the archives of whatever national archives in the Czech Republic, and they presented this as an evidence that the the copyright has been created, so to say. So that was that is more or less the background as evidence. So the heirs and some statements which said, well, it seems that Mr. R is the owner of that or has created this and that, and well, some statements of that kind were also presented. Now this came to the Board of Appeal, as I've said before, and the Board of Appeal, they went through that decision of the Cancellation Division and through the arguments which were presented by A and B. Now, the first thing was whether A and B are actively legitimated to make the invalidity claim and the action in front of the courts, and that was presumed to be, because the Harris certificate seems to be okay, so they were half and half Harris of Mr. R. So active legitimation was presumed to be okay. In the case, I said it is national law, right? So if it is a national law, then you would need to have a kind of national law produced to the boards of appeal. So meaning that the boards of appeal, like the court, they do not know all the law of the 27 member states at a certain moment in time. Here it is said that the copyright law was created in 1968. So even so, we need to know what was the law in 1968, not in the Czech Republic, but in Czechoslovakia. But in that time, it was Czechoslovakia, another country. So the boards of appeal and the Cancellation Division and the General Court, they do not need to know the law of member states in each time period, so to say. So it is subject to the individual, to the one who relied on national law to produce the national law to the instance what it is about, to the General Court or to the boards of appeal. So what the A and B produced was only a fragment of that law, which was not the complete law, which was not what is about the Czech law by the time, and even so, it has to be translated into the language of proceedings. Now, this was not a casus belli for the boards of appeal, because there were some, it could have been rejected on that account only, but the boards of appeal, for whatever reason here, has had the intention to go deeper into what is, or to expose more clearly the invalidity applicants. So there were some judgments produced from what it could be deduced by the time what was the Czechoslovakian law on copyright in around 1968. So there was at the core of the copyright, there's a work, right? There must be a work. Now, what is not clear here, what is the ownership, what is the extent, what is the scope of protection, what is the copyright on what the invalidity applicants relied on. Here on the screen we have again the PRIM. That is what they say is our copyright, PRIM. But what is the exact scope of protection they relied on with regard to the copyright? Is it, for example, the word as such? That would be one possibility, the coined word PRIM. Is it the typeface of the word PRIM, or the total, the PRIM and the typeface? Or is it the typeface as such, which is the artwork being known as a background that the Mr. R from the coiner of that word or so, that is a designer or a typeface designer, so to say. So that was not clear, meaning that the copyright was not substantiated. So that was the second point where the boards of appeal get stuck and could have rejected the claim of the invalidity applicants. Well, it went through these three possibilities. Is the copyright the coinage of the four-letter word PRIM? Well, that is not a work, right? That does not subsume under what is being required as a work, an artistic work from the copyright owner. So that cannot be. Is it the typeface of the word PRIM which has been chosen? Well, we can see here on the screen, it is the serif font. There's only some small deviances from that font, so there's not something which we can qualify about the artistic work. So even that would not qualify as an artistic work. And third, is it the typeface as such? So the typeface, it may be the typeface are not subject to copyright law, but under different regulations. But anyway, standard regulations. But anyway, we don't have the full typeface here reproduced by the invalidity applicants. There are only 4 words. Of it, 4 typefaces, but the typeface would englobe the total alphabet. So it is not a copyright. So that would be the third obstacle the boards of appeal identified in order to reject, so which could be the ground for rejection. So that was not the case. So there was no, they went on to the authorship. Who's the author? So the author, according to the invalidity applicants, was Mr. R from the Czech Republic now. Now that was in 1968. And the evidence which was presented were 2 written statements from other persons, from certain persons from the Czech Republic, which were not conclusive, so to say. We leave it like this. I do not want to go more into detail into that. And there was a meeting protocol meeting protocol from the Ministry of Trade, so from the Czechoslovakian Republic, but it appears, that was the evidence, right? It appears that the entitlement of that paper, of that meeting protocol, was not was the Ministry of Trade or so, but that Ministry of Trade did not exist at the time of the protocol. So it is doubtful what is the origin of that paper. And on top of it, the protocol was not even signed. So there's no binding conclusions to be drawn out of that paper. And it is not clear whether this is a coinage, and Mr. R was, I think, was not even present. So it is inconclusive with regard to the coinage. So we do not know whether the authorship lies in Mr. R. So if Mr. R is not the author, then evidently the heirs, they cannot get more than the author had in the first place. So the authorship was not clear with regard to Mr. R. And then you know that the copyright has 70 years plus of validity, meaning that during the lifetime, if it was, so to say, presumed it was created in 1968 and the author died in 2003, then we have plus 70 years to 2073. So we had the copyright extended until that date. That is true, right? So nothing on the validity of the presumed copyright if it was a copyright. But in 2014, 1968, so 2014 was the invalidity application, and 1968 was the coinage of the PRIM word, so to say, and we do not. So there is a 50 years in the middle, and during the 50 years, so there was no what to say, no contest, no protest, no action from the author or from the heirs of the author with regard to that copyright, even until 2010 or so. I said there were some other litigations among the parties, so it was not until 2014, but there was even before. But you know, the absence of action during long time, and namely during the late 30 years of the last century, they can be interpreted as a presumed consent, as an implicit consent on the part of the author of the presumed copyright. So also this can be used as a rejection of the invalidity application. So my point here is that a copyright is a possibility for making valid invalidity application against EU trademark, right? So that is a possibility, or national trademark, or whatever, that is possible. But on the other hand, it has its complications, as you can see. So here we had 2, 6, 7, 8 possibilities to reject the copyright if we went through all the way. You have a rare occasion here where the Boards of Appeal went through all 8 possibilities of rejection. It was not necessary. It was a kind of scream to the invalidity applicants: don't go to the general court, you will lose surely. And what happened? They went anyway, but they lost their case in January 2021. So read the very instructive masterclass of the Boards of Appeal decision in order to get a more concrete grasp on the copyright.